Well, hey, back again here, and I want to admit to you right from the beginning that next two cases that I'm going to talk about for 4 and 5 are troubling to me even, and I'm not exactly sure why they came out this way, but I'm going to share my thoughts on it at least. The first case is Virginia versus Black. Virginia versus Black. The case opinion is 538 U.S. 343, and that was in 2003. And this is a case about Barry Black and 2 other friends who were convicted for violating a Virginia statute that makes it a felony for any person with intent to intimidate any other person or group to burn a cross on the property of another, or a highway or a public place. And basically what it says in there specifically is that any such burning shall be prima facie evidence of an intent to intimidate a person or group. And in this case, what it was a Klan rally, Ku Klux Klan rally, held on private property. And in that rally at the end, these people gathered around a cross and set it on fire, and then over a loudspeaker system there was playing of Amazing Grace, which is a religious song. Now, 2 different people testified that they observed this. One of them was the sheriff of the county where this happened, and the second one was a private citizen who was sitting on her front porch. And basically the sheriff testified that it basically violated the letter of the law in terms of he observed everything they did, and I basically described it. And then the woman that observed it said that she was very intimidated and very upset by what happened, and she thought it was like really scary. And so the case went up to, first of all, the Virginia Supreme Court, and they determined that the cross-burning statute was unconstitutional and in a violation based on some other cases that we will also talk about. Well, one of the things is that the case then proceeded up to the United States Supreme Court, obviously, because that's why we're talking about it. And in that part, I mean, there was a 7-2 vote in favor of the state of Virginia, and basically what it's saying is that the decision was basically upholding this Virginia Supreme Court's decision. And I guess what they're basically saying is that the language was flawed, because it's this whole thing about a prima facie case, that it's more or less absolute proof if someone just burns a cross on someone else's property. Well, in this particular case, first of all, they burned it on a willing participant's property. It was not on private property in the context of, let's say that they went on to the lawn of a black family in a certain neighborhood and erected a cross and set it on fire, which has happened many, many times. And so basically what ended up happening in the larger picture of this is that the state of Virginia passed a different law. Instead of saying cross burning, they just said object burning with intent to intimidate, and took out the part about prima facie evidence. So I think what they're saying is that you can't say ipso facto that burning a cross is bad. I think if you put this in the context, it was on the private property of a willing participant, not on a victim's private property, which I think might have been more what their intent was, because that's the way it used to be done. The other thing is that basically that, they did have a cross and they played a Christian song. So in a way, I think they might have thought that they were interfering with free exercise of religion, which is also a First Amendment right that we have. So I think what they said is the way the statute was written is just not technically correct. So that's a situation there where we're getting into like really the fine points of legislation, how to write it, and this type thing. But it is troubling to me, to just say the least, is that I don't think it's good to allow those kind of demonstrations where there's fire involved, just from the standpoint of possible other outcomes in terms of burning down a whole forest or a field or something like that. And I do believe that people, because of the history behind this, you cannot ignore that history from the standpoint that people assume that it means intimidation, and so I think there ought to be rethought somehow. But it's one of those where it's tough to draw the line. You look at it in a context of Brandenburg, which we talked about, versus Ohio. Difference there was it was not speech in the same way that Brandenburg said certain things, but it was more of a demonstration. And some people, including Justice Thomas, said that the performance aspect of it in this case, because it did involve fire and a history and tradition of intimidating blacks, was different than just pure speech, because it was taking another step further in terms of, just talking about it, whereas carrying forward on a threat, that would be more of an actual step, I would think, toward committing some kind of a crime. So, that's just the way I'm looking at it. I can see the clear difference between this and Brandenburg, but apparently the court did not see that Virginia versus Black was that different from Brandenburg. So basically, it's up in the air. My question to you, though, would be, if you wanted to follow up on this, this would be a good case to comment on, just in terms of your opinion. Would you feel that it was intended to threaten or intimidate someone if someone burned a cross, even though it was on a willing participants? In other words, this was right in view of a highway, right in view of a neighborhood. There were homes nearby, but the owner of the property was in favor of it. So, well, moving on, we'll just move on to the next case. Next case is Boy Scouts of America versus Dale. The argument here was that Dale was a homosexual. He was an assistant scoutmaster. The case here is 530 U.S. 640. It's a 2000 case. Very interesting case. New York statute prohibits any kind of discrimination on the basis of sexual orientation, and this was in public accommodation. So that means even anything where basically people are involved, and so the question there becomes, how do you do that from the context of private clubs? Other cases that we've had, like the Moose Lodge case that we've talked about in the past, is kind of saying that private clubs do have the ability that they can say, well, this is a closed door and you're just not invited. And so it's up to the member to decide, do I want to be a member of a club that excludes certain people? And in this particular case, they said, that the Boy Scouts actually have certain First Amendment rights, not just Dale, but the Boy Scouts. So that the Boy Scouts, this is a very close decision, 5-4, but basically what they're saying is that this statute is unconstitutional as it's applied to these non-profit private clubs like the Boy Scouts. And so this is another one that's kind of troubling to me, and I just kind of want to get both these out of the way all at the same time. Here again, the statute was changed by the state of New Jersey, and so the question is, whether or not the Boy Scouts can continue to exclude any kind of a homosexual at any level, whether in a leadership level as a scoutmaster or as a member, as a child who is a member of the Boy Scouts. So it is interesting, though, that I noticed that effective January 1st, 2014, that the Boy Scouts have changed their policy on this. And they've said that they're not going to make homosexuality as kind of a linchpin decision maker on whether or not a young person or a scoutmaster can be a member of the Boy Scouts. Basically what they're saying is that you can be a member of the Boy Scouts if you meet all the other requirements of the Boy Scouts, which is, the Boy Scout creed, be prepared, and they have it's a Christian organization. They talk about God, and they talk about honor and duty, and it's kind of a paramilitary organization, always has been, but you have to basically live up to these highest standards as far as your behavior and so forth. And so what they're saying is that if you live up to these standards, then the mere fact that you're homosexual doesn't necessarily exclude you from the Boy Scouts. And so I think they've changed their whole tune a little bit within the organization in relation to what happened in Dale, which, as I said, happened back in 2000. And so basically what we're looking at is that I think there's been some degree of change over a period of 13 years. The other part is this was specific to New Jersey. What I'm talking about as far as the changes are at the national level. And so, there may still be pockets around the state of Boy Scout groups that are going to exclude homosexuals, but only by making it some other rule that they say the person might have violated in terms of their character. And so basically those are these two cases. These are hard cases. Obviously, if I'm struggling a little bit with them, then you know that they're tough. But here again, if you want to comment in Form 5 on either the intimidation factor in the Virginia versus Black case, or if you want to talk about the homosexuality aspect in the Boy Scouts, should homosexuals be allowed to join the Boy Scouts? Should homosexuals be allowed to come out of the closet in the U.S. military? Anything like that that you want to talk about is related to this topic. So basically, there's two different angles to this. There's the angle of what's the group feeling of whether they want to have members like that in their group, or what about the individual feeling of I want to associate with who I want to associate with. Yes, that's other homosexuals, and yes, that's the Boy Scouts. And so, is that discrimination? Okay, well, give these a look. Tell me what you think, and we'll be back later with some more information. Thanks.